Today on the Brisbane Property Podcast, we're joined by Chris Burling from Business Depot.
We are going to be covering everything that you need to know about the new seller disclosure regime being rolled out across Queensland on the 1st of August this year. We hope you enjoy this episode.
Welcome to the Brisbane Property Podcast with your hosts, Melinda and Scott Jennison.
Hi, everyone, and welcome back to another episode of the Brisbane Property Podcast. Scott and Melinda Jennison, and today we're joined by Chris Burling from Business Depot. Welcome back, Chris.
Thanks for having me.
Chris has been a very popular guest previously, and he has been invited back on the show today because there is some major legislative reform happening here in Queensland, and we have a new seller disclosure regime rolling into effect as at the 1st of August this year. So Chris is going to share everything that you need to know to understand your obligations as a buyer, also what you need to understand as a seller so that you can get a better, understand what's coming and how this affects you in the market.
Chris, before we do jump into it, can you give us a little bit of an overview from the Property Law Act? What's triggered these reforms?
Yeah, no worries. So I guess firstly, it's good to hear I'm so popular. Lawyers aren't usually, but so this has been in the works for a few years now. In 2018, QUT Legal Research Centre were commissioned to do a report on the reforms, and essentially the property law bill was formed as a result of that, using most of the recommendations from the report. Generally speaking, there's a lot of minor changes to the Property Law Act because it's from 1974. So just to modernise and streamline a lot of processes in transactions and just everyday property.
Yeah. It is interesting because we are so far behind other states.
Yeah, I mean, if you look at New South Wales and Victoria, there's already a well-established disclosure regime. And the proposed disclosure regime for Queensland is probably one of the biggest changes proposed, which are now to be implemented.
And so for those listeners that don't understand, right now in Queensland, there is no seller disclosure obligations that we're not provided with a disclosure statement except when you're buying under a body corporate scheme, although the information that's provided under the current disclosure statement when you're buying under a body corporate scheme or a community title scheme is only going to be a very small amount of the information that's going to become available to you as a buyer. And that's why this is really important information. So help us understand, Chris, why is this shift away from sort of buyer beware such a big deal for us here in Queensland?
Yeah, so it's one of the biggest changes to the Property Law Act since it was first established. It obviously we're moving towards a more buyer-friendly position in the conveyancing process, which is obviously a positive. I mean, the objectives of the disclosure framework were to sort of clarify what a seller has to disclose, because you'll notice that some of the disclosure obligations are consistent with other legislation, but sellers may not have previously known about that. So now it's all in the Property Law Act. The other thing is trying to balance the information cost between the parties. So traditionally, buyers have to undertake all the searches. And I suppose the intent was to share that cost with sellers, although I don't necessarily think that's been achieved as intended.
It's interesting because you rightly point out that, there's a lot of cost to the buyer right now. There's a lot of due diligence that the buyer needs to do under the current regime because it's completely buyer beware. And so a lot of the things that will be disclosed under this new legislation, right now buyers don't get that information before entering into a contract. But it is all changing from the 1st of August this year. And I guess if you're planning to sell a property, if you're planning to buy a property, even if you just want to understand what's going to happen after the 1st of August, you just need to know how this seller regime is going to be rolled out. So, Chris, what exactly is changing? So what do sellers now need to provide under this new legislation?
Yes, so from the 1st of August, basically there's two elements. The seller has to give a disclosure statement, which is signed by the seller in the approved form, which is available now, and we can share that in the comments. And then in addition, there's a list of certificates or documents that a seller has to provide. So that should be provided in accompaniment with the disclosure statement.
And that approved form is what we call a Form 2, is that correct?
Yes, that's right.
So that Form 2 is going to be something that as a buyer you should receive up front. It's going to have a lot of additional information, and we will cover what should be included in that Form 2. And there's some rights of termination if that's not provided, which we're going to cover in this episode as well.
Chris, a lot of listeners will probably be thinking they're just talking mumbo jumbo here, and there's a lot of information and probably too much information for the average sort of person purchasing a property. Can you give a breakdown a little bit of what's new and what was actually existing previously, so that people can understand what sort of changes are coming in?
Yeah, absolutely. So there's already information in the disclosure statement that you would receive just via the contract or in the sales process anyway. So things like the seller name, the property address, property information, like title reference, generally details of unregistered encumbrances or statutory encumbrances, they're already being given. And I think selling agents are a lot better now than a couple of years ago in doing those dial before you dig searches and disclosing. Details of residential tenancies. So they're generally already provided. There's a couple of other things that are supposed to be provided, but aren't necessarily. So things like transport resumptions, or if the property's on contaminated land register. So we would always independently verify that with a search anyway, but that sort of brings that obligation into this disclosure statement in addition to those different pieces of legislation.
So that actually brings forward the information to a buyer so it's known up front, rather than the buyer having to complete searches perhaps when they're already under contract or prior to entering a contract. So it puts the obligation of the cost, I guess, back onto the seller to give this information up front. Yeah,
that's right. So, I mean, using the contaminated land register as an example, if you discover that the property is on that register, you do have a right of termination under the Environmental Protection Act. But this essentially, provided that the seller does the search and provides that with the disclosure statement, which they're not necessarily required to do, it's more so disclosing if it is, that definitely saves some cost to the buyer.
Absolutely. What else? I believe there's Heritage Act, swimming pool details, things like that as well?
Yeah, so some of the new things that aren't necessarily featured in like the REIQ version of the contract. So there'll be the heritage considerations, the total amount of rates and water charges payable, which is quite interesting because it's not something that you really ever see in a transaction until you do the searches. So unlicensed building work is a really interesting one from our perspective, because there is some sort of statutory protection in the QBCC Act. So if a seller doesn't disclose that unlicensed building work has been done, essentially that has the effect of a contractual warranty. So if later on you discover that it has been done to the property and the seller didn't tell you, you can actually take an action or a claim against the seller, and rely on that statutory protection. But as we know, very rarely will a seller disclose that.
Absolutely. Onus is on the buyer to
Chris,
uncover that.
Just on that one, and this is, it's just a different question on that unlicensed building side of it. Do they have to then own a builder side of it? Do they have to disclose that it was an owner builder, or if it was a licensed builder?
So if it's an unlicensed, whether it's owner builder or not, it has to be disclosed.
Cool.
Yeah.
Okay.
I know from the information that I've learned about this new legislation, there's going to be some things that there'll be a warning statement provided, but not necessarily the detail that will give absolute certainty for the buyer. Those things include overlays such as flood impact. So, you know, there's not going to be disclosure around flood for the property, but there's going to be links provided in the Form 2 to help the buyer understand where they need to go to get further information. And I believe also vegetation or protected overlays also not going to be disclosed, but a warning provided so buyers are aware that they need to do further due diligence. Is that the case?
Yeah, that's right. And that is essentially, I mean, all of those things buyers should be looking at anyway. And obviously a good buyer's agent and a good lawyer will do that for you. But it is a good reminder, especially for people that are unrepresented when they're in the negotiation phase, to go and look at those things before they proceed further.
And I know one of the things that we often get inquiries about from clients that we partner with is asbestos. Scott, asbestos in Queensland homes. Again, a warning only provided, but no obligation on the seller to disclose whether the property contains asbestos.
I think that one would be pretty general if it was in Brisbane and you're getting within probably 10 k's of the CBD. There's a pretty good chance there's going to be asbestos in a lot of the houses.
What's interesting, Chris, can you just talk us through some of the changes to community title schemes in terms of the information provided? I believe at the moment a CMS must be attached.
Yeah, that's right. But I mean, otherwise it's not significantly different because the disclosure requirements for a community title scheme have been around for some time. And there is basic sort of information about the scheme. But I mean, as we have seen through a number of transactions together, that there's quite often things that are missed from the disclosure and things that we sort of only pick up from a comprehensive search of the body corp records, which I think it is very relevant for this disclosure statement because it's one of those things that you can't necessarily rely on the disclosure, especially when you write sort of subsist at settlement.
So, Chris, this is not just a form that is completed that's provided with the contract. There's also going to be additional evidence, I guess, additional documents that need to be attached to the form too as part of the disclosure requirements. Can you talk through some of what those additional forms will be? Because, for example, at the moment, you can enter a contract in Queensland and literally the full agreement can be captured within a single contract of sale. There's no requirement for additional documents, whereas that's going to change as well. Can you just talk us through what some of those additional documents must be supplied with the contract?
Yeah, so that second limb of the obligation on the seller to provide the certificates, so they're all prescribed by the regulation. So at the moment, obviously subject to change in the future, but it is a copy of a title search, which is pretty common to get anyway now, a copy of the survey plan from the titles office, and then the rest sort of relate to items on the disclosure statement. So, for example, if the property is subject to a show cause or enforcement notice under the Building or Planning Act, then you have to provide a copy. If it's on the Contaminated Land Register, you have to give a warning notice. So they all sort of tie in. The issue with that is probably, again, that if the seller doesn't provide it, the only way you can verify that is by actually carrying out your own searches.
So the seller doesn't have to provide, but has to give notice if they're not providing it?
No, so they have to give notice if it is on the register, but they don't have to give you a copy of the search to confirm that. So if they don't give it to you, the only way to check is carrying out your own search, essentially.
Yep. And are the requirements that need to be provided, are they the same across all freehold land transactions?
So there are some exceptions, but I mean, the exceptions are so rare that generally most people won't have to worry about them for everyday transactions. So some of them include like related party transactions between family members or related entities, boundary realignments between neighbours, which we don't see very often, contracts that give effect to a court order. So things like family law proceedings where they're transferring properties between one another, or properties where the sale price is more than $10 million. So there are a few
exceptions to the rule.
Yeah, but there's also like buyers still have to sign a waiver notice, so it's not a complete exception.
There's a lot of additional, upfront work required by a seller, and something that I've been discussing with my buyer's agent community is how will this impact on the availability of off-market transactions, because now there's a commitment from the seller that must be made before a contract's entered into. And it's an interesting observation because, right now, if there's agreement between buyer and seller, that transaction can happen pretty quickly in that off-market space, whereas it's going to take a little bit of time to pull all of these documents together, I would imagine. And from what I understand, and correct me if I'm wrong, it's going to be important for a seller to engage a solicitor upfront to obtain this information, or potentially work with their agent. And I believe agents are partnering with some platforms that can pull some of this information together as well. But how long will it take to gather all of this information, in your opinion, to be ready to even enter a contract?
Yeah, look, it's not I mean, initially we were sort of thinking that this function would pass on to solicitors.
Yeah.
But I definitely agree that we can see, the REIQ are producing some really great resources and things that help agents complete it for the clients. I guess just depends on the agent's risk appetite and whether they're willing to take the risk on potentially losing the contract over, the failure to disclose something.
Yes. Yeah.
But I mean, in terms of timing, there is a lot of information, but it's not a huge ask as long as the seller is sort of prudent and aware of, most general things about their property, which shouldn't be too difficult.
So really it shouldn't slow down those quick transactions that could take place maybe a day or two, but not a matter of weeks, depending on, I suppose, what needs to be disclosed.
Yeah, that's right. I mean, you might have a client who's living overseas and, hasn't lived in the property for 10 years. And of course, there's going to be delays with that. But for the most part, I would say 1 or 2 days max to get everything together as long as everyone's organised.
Perfect. Sounds good. So in the example where, say, a Form 2 is provided to a buyer, but there's something that the seller fails to disclose, something that's important, or perhaps that information is inaccurate. What happens in that scenario?
So, essentially, I mean, the disclosure framework has created a termination right for a buyer. So the termination right is two-pronged. If you don't receive disclosure or if you do receive it and it's, there's a material mistake, but for that mistake, you wouldn't have entered into the contract. And that sort of, I suppose that brings about another conversation down the track as to what's material and acting reasonably and being objective about that. So,
and at what point is that right up to settlement?
That's right up to settlement. So, I mean, I've been seeing a lot online about the changes, and there's a few myths floating about, and I actually saw something on LinkedIn the other day that, a real estate agent had contacted a seller and said, if you get this wrong, you're going to get sued and it's going to cost you thousands. And I mean, at the moment, the framework, like the Property Law Act, only provides for that termination right up to settlement. So, I mean, it's important that as a buyer, you carry out the searches, do your due diligence, and check everything off in that disclosure. Because any sort of recourse or claim for compensation or damages would be, using common law remedies only. So it's not necessarily provided for in the Act.
One thing that I've learned as we've all become more familiar with this new legislation is that on the Form 2, that is the disclosure statement, there is a placeholder for the seller to sign, and the seller in this instance would sign first. And then this form is provided to the buyer prior to the buyer entering into the contract. And there's also a placeholder for the buyer to sign this particular document. But what happens if the buyer has been provided with the disclosure statement but doesn't actually sign it? What happens in that scenario?
Yeah, it definitely creates an issue because, I mean, the first thing a reluctant buyer is going to do if they want to pull out of the contract is start thinking, well, how can I pull out? Did I receive the disclosure? If I did, is there a material mistake? And that's, I mean, agents really need to be careful and make sure they're including it in like the DocuSign packages and things like that, just so they can confirm that it has been received.
So there's no onus on the buyer to have to sign the disclosure statement. It's the onus on the selling agent or the seller to prove that the buyer's received it prior to signing. Is that correct?
I would say in the event of a dispute, you would definitely want to have evidence that you've given it to a buyer for sure.
Yeah. And I think that's something that, as a buyer also don't just assume because you haven't signed the disclosure statement that it can't be proved that you haven't received it, because that's definitely not the case. If you've received it by email, if it's been, sometimes you receive the contract and all of the documents by looking at a QR code, and that gives you the ability to download these documents. In many instances, that can satisfy service of these documents. So it's important that you understand your rights as a buyer, but also understand what rights the selling agent and the seller actually retain as well. So we don't want buyers to be assuming that they can rely on this to get out of a contract when in actual fact you don't have to sign the document. You just have to receive the document and receive it prior to entering into a contract and signing the actual contract.
Chris, any exemptions for it?
For receiving?
Yeah.
Probably just the same, like the exceptions in terms of related party transfers, over 10 mil, things like that.
Yep.
And if we see the disclosure statement being provided, there's no disclosure provided. Sorry, if the buyer retains the right to termination anytime before settlement if there's no disclosure provided. But again, the buyer would have to prove that they didn't actually receive that. Is that correct?
Yeah, that's correct.
Okay. But if there's also a material mistake in the disclosure statement about something that is known, there's a right to termination. That's correct?
Yes.
Okay. But if the buyer was aware of an issue and then that wasn't disclosed in the disclosure statement, this becomes very grey, doesn't it? Because they have potentially received a disclosure statement that is incorrect, but the buyer is aware of the mistake in the disclosure statement but goes ahead and signs the contract. Is that a little grey?
Yeah, especially at this early stage. But I would say if the disclosure was made in some other way, then at least the seller would have some sort of argument that, a supplementary disclosure was given at least before the contract was entered.
Yeah.
If after the contract was entered into, I think it's too late at that point. But certainly if they've got a chain of correspondence showing that it was actually disclosed correctly, I don't think the omission from the disclosure statement would necessarily be fatal to the seller's claim.
Just on the date of this, the 1st of August, is that the date that the contract is signed? So if someone's doing a sales campaign and they've got an auction coming up and it's going to sell, I don't even know what the day of the week, the 1st of August is. But, if you've got an auction campaign coming up, obviously agents would have to say, hey, look, let's do it all now because the contract could be signed
after the date.
After that date.
Yeah, look, I mean, I'd look at even starting, say, a week before, because if a buyer or a seller signs the contract and it gets submitted to the other party, and then you cross over that date threshold, then you're required to do it. So definitely get in early as possible.
We might actually see a little bit of a slowdown in real estate transactions between the last week in July and that first week in August, as a lot of agents actually ensure that they are going to be compliant, because you're right, if we've got that crossover and all parties haven't signed by the 1st of August, it's going to trigger the disclosure requirement, and it could be midway through contract signing. So that could be an interesting time in real estate in Queensland. And if you've reached agreement with a selling agent, but they're holding off on signing a contract, it could be because they do need to be compliant with this new legislation. So just something to be aware of if you are a buyer in the market.
Do you think it'll change the way that people purchasing property? Because we look at, say, for an example, an auction, and it's cash unconditional. So there's no building and pest. You waiver all your rights. Do you think it will change in a way that people do look to sell property? And maybe this is a question for some sales agents. Obviously, they'll provide all the information. If you talked about the heritage, all those things that you've talked about, maybe a building and pest inspection, they might supply that as well. So it's a whole package, so that it gives the buyer more confidence knowing that the property is actually cleaner, I suppose.
Yeah, for
make
sure.
It a smoother sale, I guess.
No, I definitely think it'll improve that process. I think my only apprehension with everything, and I don't want to sound hypercritical of it, but at the end of the day, it's sort of bringing together existing obligations, and there's a few others, but nothing, like, it isn't anything too groundbreaking to protect buyers. I mean, buyers still have to be cautious. And I would hate to think people become complacent in their due diligence because of this. If they think, oh, well, I've already got everything, I don't need to spend money on searches, because you could very easily go and do the conveyancing, not do any searches, get to the end of it and realise that the disclosure was wrong. It was on the contaminated land register. There was an approved resumption, but it wasn't disclosed. And then even if you were to sort of claim damages through some common law remedy, then you have to prove that you've got to outlay a huge cost for litigation. So it's really, it's great, but it's not a replacement for advice or due diligence or searches.
I'm glad you've said that, because the role of a buyer's agent does not become redundant as a result of the new legislation that's coming in. And in fact, one could argue that it becomes even more important to verify the information. A lot of this information that's now being provided up front is information that we, in the role of a buyer's agent, would ordinarily be obtaining to advise clients before they're entering into a contract anyway. So really, this is just simplifying the process by giving it to us, but we actually need to verify and cross-check a lot of this anyway before we're guiding our clients through the next steps. So in the event that there is a termination right and a buyer chooses to terminate the contract because they weren't provided with the disclosure statement or there was something that was incorrect within that disclosure statement, how do they go about, like, they get their deposit refunded and
yeah, that's right. So I suppose you would issue a termination notice and the basis for terminating. Obviously, the seller solicitor has to then review that and confirm that it's all correct. And then essentially, provided that it's agreed upon, then there's a 14-day period for the deposit to be returned to the buyer.
Okay, great.
I was going to say, apart from doing your own research, obviously as a buyer, as we talked about, we do all the due diligence, we do the searches, we check everything out, underground services, approvals, all that. We do all of that work as well. And as Melinda said, and you said, Chris, you don't want to be complacent on it. So, I mean, I think it'd be not saying it was a silly thing to do, but to rely solely on what you're provided, you're putting yourself at risk still anyway. And even the heartache, if you want to buy that property and it happens to, something's wrong and it falls over, then you've got all the stress and all the headache from that as well. So continuing to do your research and making sure everything's right and getting the right team around you, and obviously cross-checking everything that's supplied as well. I think that's really important.
Yeah, I think like having worked with you guys for a few years now, like knowing what the process is, I don't think it changes how you work or how we work in that conveyancing process after you've sourced a property, because I know the clients are coming with all of those initial searches being done and then what we're doing as well. So
yeah. And obviously a lot of people that listen to our podcast, they're not necessarily buyers, but they're potentially looking to sell. Most sellers become buyers, so perhaps they're both. But, is there anything that sellers should be thinking about now in the lead up to this change? Is there anything that they should be doing?
I mean, definitely becoming educated on it, because eventually one day they'll have to sell. I know there's talk of people rushing to sell before the disclosure.
Do you think that's happening? We're buyers. Don't buy before the 1st of August. I'm kidding.
I'm sure it's possible. I doubt it. And I mean, from a buyer's perspective, I wouldn't be too concerned as long as you've got a good buyer's agent and a good lawyer. Anything's going to be picked up anyway that's not disclosed.
That's true. Yeah. And then if there's anything in terms of a final piece of advice that you'd give, obviously, this is new legislation that's coming in. This is something that people need to be aware of. But what's the single most important takeaway that you'd like to share with our audience about this legislative change?
Yeah, I think just to reiterate, the biggest piece of advice I could give is not to become too reliant on the disclosure statement. Yes, it's a step in the right direction, but I don't think in terms of buyer protection it's quite where it needs to be. And obviously there's time for that in the future, but I think if you rely on it too heavily and substitute that for good advice, then you could run into a lot of problems.
Yeah, it's really good advice to give buyers out there. Yes, it's going to protect you to some extent, but it's not the holy grail of disclosure, and it's so important that you understand where you need to go to get all of the full scope of information to protect your interests as a buyer.
Yeah. Well, thanks, Chris. I think you've given a lot of information. Obviously, as we've said, 1st of August comes into play. So beware, obviously, do your homework, make sure you get the right advice if you're buying or selling property as well. Thanks very much. I think it's been great information you've shared with everyone.
Yeah, thanks for having me.
Yes, thank you once again, Chris, for joining us on the Brisbane Property Podcast. I know we'll see those downloads scale up because they can see your name as our guest once again. But look, as always, we hope you have enjoyed this episode. Please share with friends and family. Anyone that's looking to buy and sell in Queensland in the near future really needs to understand this new legislation and what it's all about. So we'd love for you to share this episode. We'd love for you to also leave us a review on your favourite podcast player. Hit the subscribe button if you are watching on YouTube. Look forward to speaking with you again soon. Until then, bye for now.